But first, we will begin with this story concerning Robert De Niro. And unfortunately, I don't have the lawsuit because this was filed in state court, so I don't have access to the New York system, and I'm not going to establish an account just to pull one story because it's just too much of a faff. So we'll just cover what Variety says, who, as best as I can determine, is the publication that broke the story. So we'll give them credit for it because they broke it, and we'll just describe what they're having. Robert De Niro's company has filed a $6 million lawsuit against a former employee, accusing her of embezzling money and binge watching Netflix while on the job. Canal Productions, De Niro's company, accuses Chase Robinson of racking up exorbitant hotel and restaurant charges. According to the suit, Robinson was hired by De Niro. She was later promoted to vice president of production, and her salary was $300,000. That's a pretty good salary, right? The company says she rarely came into the office and allegedly spent extra astronomical amounts of time watching Netflix during work hours, which is the part of the story I thought would most capture everyone's attention, because perhaps there might be some people who are watching YouTube or Netflix during company time. So this is your note for the day. The company alleges that during a 4-hour period in January, she watched 55 episodes of Friends. On those days, she ordered lunch from Caviar San Francisco and had dinner at Palaio's restaurant, charging meals on the company credit card. On another day, in a 4-day period in March, she allegedly watched 20 episodes of Arrested Development and 10 episodes of Schitt's Creek. Watching shows on Netflix was not in any way part of, related to the duties and responsibility of the employment, and was done for personal entertainment, amusement, and pleasure at times she was being paid to work. Suit also alleges Robinson made $12,500 in unauthorized charges at Palos, which is a restaurant, over a 2-year period. So $13,000 at a restaurant, that's good work. In addition to $10,000 at Dean and DeLuca's and Whole Foods, and $32,000 for Ubers and taxis. That's a lot of Ubers and taxis for $32,000, but hey. So again, we don't have the lawsuit, and again, this is an allegation, so we don't know any defenses that would arise, but they're suing a former employee for $6 million in presumably both damages and back pay. So they want some of their money back for the money they paid their employee because they weren't actually working in the scope of their employment. So, and I don't know how California law. This was filed actually in New York, I believe. Yeah, it was filed in New York. So I don't. First of all, I don't know the relevant law that's going to be covered in terms of where this business is organized. The article doesn't say. So I'd want to know how De Niro's business is organized, what state it's based in. I'd want to know in terms of the contract if it said choice of law provisions, a whole bunch of things. So we don't necessarily know what state law even applies. Even though this is being filed in New York, doesn't necessarily mean that this is being decided on New York law, because most contracts of this kind usually have a provision called a choice of law provision that says what kind of law is going to be applied, and you can make that decision as part of a contract. So even if it's being held in New York and being heard by a New York judge, they would still apply the law of whatever, as long as it is a reasonable choice. So I don't know if California law would apply, which you might expect because it's a production company related to entertainment. New York law, some other state, who knows? So don't know what defenses would apply, but just thought it would be an interesting story.